Доброго дня. Good afternoon, dear colleagues, partners, friends. I'm happy to announce the opening of the annual Congress of the Regional Justice Sector Support Councils. We are streaming live in 6 different places in Ukraine. So let's hope that this technical challenge will not prevent us from conducting a constructive, effective, and friendly discussion. Let me start by saying that regional justice sector reform councils were introduced already a couple of years ago. Our project, funded by European Union, Pravo-Justice, was one of the main facilitators. However, I think we can already say with sufficient certainty that in those couple of years we have achieved a good level of participation in all the regions of Ukraine where we are working and where the councils are active. We have achieved results by way of specific policy proposals, some of which are now currently pending in Parliament, such as the mediation bill. And I hope we achieved sustainability by way of showing to the central authorities in Kiev that Ukrainian regions have enough capacity, intellect, understanding, and the sense of motivation and initiative to drive the justice sector reform forward. Without further ado, I want to give the floor to the Ambassador of the European Union, Mr. MAACIKAC.
Many thanks, Dovydas. Everybody, I'm really happy to welcome you all today. Wherever in Ukraine you may be physically at this moment. And may I assure you that you are carrying a particularly important mission in Ukraine, that of the promotion of the rule of law and legal certainty in Ukrainian society. Rule of law and smooth functioning of the justice system is crucial for Ukraine's transformation, for its socio-economic development and attraction of investment. With that, of course, and in addition to that, to the closer association with the European Union. Rule of law is the glue that keeps the society together. It's a key foundation on which modern democracies and economies are built. You know better than me that Ukraine's justice system is still facing a number of challenges. Shortage of staff, divergent court practice, underdeveloped e-justice infrastructure, incomplete enforcement and bankruptcy reform. In addition to that, higher independence, accountability and integrity within the judiciary are key for ensuring a real access to justice and continuation of crucial reforms. We all were recently reminded of that again by the decision of the Constitutional Court, striking down the big part of the corruption prevention. We still hear complaints from Ukrainian citizens and foreign investors about various problems with courts, with law enforcement, with property rights protection, and so on. This is why promotion of justice sector reforms is the EU's top priority in Ukraine. We are doing our best to support your path towards a fully functioning rule of law. Our support is multifaceted. It ranges from intensive policy dialogue with the Ukrainian government to various forms of technical assistance and capacity building, provided by our programs, just as the flagship Pravo-Justice program. We are also providing macro-financial assistance to Ukraine upon fulfillment of important structural policy conditions, including conditionality in the... Last but not least, we are empowering Ukraine's legal community, both in Kiev and in the regions, so that you can play a meaningful role in the reform effort. We truly believe that the Regional Justice Reform Council is a vibrant network of regional leaders that has already proven its capacity to produce high-quality analysis. Many of these recommendations ended up in draft laws, like the draft law on mediation, and in various strategies, like the transitional chapter. So I want to thank you all for your very, very important and meaningful work. Thanks for the cooperation that the EU and the EU delegation in Kiev has had and is having with you. And may I wish you all the strength and perseverance and success in your work for the rule of law in Ukraine. Ukraine needs it. Thank you very much.
Thanks so much, Marty. Let me give the floor to our Ukrainian counterparts. So first, I want to introduce Mikhailo Burominsky, our friend, our counterpart, our partner in dialogue on various issues regarding the justice sector reform. Mikhailo is currently occupying a position, among others, as the Deputy President of the Legal Reform Commission under the Office of President. The floor is yours, Mikhailo.
Дякую, Довідас. Мені дуже приємно вітати всіх тих.
Dear friends, it's my pleasure to greet all of you in this conference hall and online. The initiative launched by the EU Project Pravo-Justice which is related with the creation of regional platforms, is a very important and meaningful initiative. It proved to be effective, and it makes some real actions. I had an opportunity to attend regional meetings Such meetings bring together people who are facilitators of the justice sector reform movement in the regions. Thanks to them, we've managed to set up really powerful platforms across the country. These people demonstrate the potential of their regions and also contribute to the establishment of the partnership relations between their respective regions and the center. They facilitate the projects and initiatives which are of great importance for the justice sector reform in Ukraine. I truly believe that the RJRC initiative will continue being successful and will manage to complete the justice sector reform in Ukraine as it was expected. I truly believe that the result we will manage to achieve will not only be formal, but will really bring about a greater rule of law and legal certainty to this country. I wish you all good luck, stay safe, stay sound, which is very important under the current circumstances. By the way, Dovydas, I welcome your efforts on bringing everybody together under such difficult circumstances. Thank you. Thank you, Mikhailo. And now I'm happy to give the floor to our friend, partner, and stakeholder, Oleksandr Banchuk, Deputy Minister of Justice of Ukraine. Thank you, Dovydas. Good afternoon, colleagues. It is indeed a very important event, and I'm happy we hold it despite all difficulties and lockdown restrictions. I would want to say a few words about why this event is so important. Before I was appointed in office, I worked in a research and development organization, and we worked not only at the central level but also in the regions. One of the projects launched by my previous job is still ongoing. It consists in mobilizing experts for making analysis all over the country. Why that project was so important? I'll tell you. It's quite easy to concentrate good experts in Kiev and make them work, while it's much more difficult to mobilize good people in regions and pick up their feedback from the ground. Now, when in Deputy Minister's office, we continue working closely with the regions, and we hold multiple surveys and conferences and seminars and workshops in the regions in order to pick up information and data from the regions. For instance, today we've had a discussion on forensic reform. We have good experts in the area in Kiev, but it's more important to get some data and responses from the regions. That is why we've collected some 1,400 responses in the framework of various surveys from the regions. So, contacting the regions and considering what the regions think help having a more comprehensive vision on various issues. So the feedback from the regions contributes to the development of respective strategies, work plans, concepts, while also to the greater realization of our initiatives. And the last but not the least, the Ministry of Justice came up with an idea of holding public consultations on various pieces of legislation and bylaws. The draft law is currently pending before Parliament. The draft law is designed to make public discussions of various pieces of legislation and regulations common thing rather than an exception. So we would want see public discussions bringing together experts, but also simple citizens to come up with their opinions on various pieces of legislation. In our opinion, it will give a broader perspective and would facilitate greater elaboration of respective legislative acts. So we would want to stick with brand new standards of interaction with the professional community, but also with citizens. And we want this practice to be enshrined in law and duly formalized. Thank you, Alexander. We also noticed that it is sometimes quite difficult to ensure horizontal coordination between different branches of powers engaged in legislative process. So I'm really grateful to you, to Mikhailo, and to other partners who facilitate and contribute to such horizontal coordination. In the meantime, our today's event has also been designed to discuss various ways of receiving feedback bottom up from regions to the central level. Let us go to the core of our today's discussion, and I would suggest to start session 1, which will be moderated by Oksana Tsembrivska. Dear ladies and gentlemen, please stay with us. We will be back online in a few minutes.
Шановні колеги, доброго дня.
Dear colleagues, good afternoon. I'm very happy to meet you at our meeting today, and I would like to start our next panel discussion, which is the main one. And we will represent what we have achieved, our success stories of all the regional councils. Before we start talking about our outcomes, I would like to recollect about the goals and what were the aims, why we have established those regional accounts. So what was the main aim when Pravo-Justice initiated this establishment of regional councils? And now I would like to pass the floor to Mr. Carson, who is the main coordinator of the regional councils.
Everybody for being here and meeting under these really exciting conditions. Indeed, I have been asked to wrap up again or to remind all of us to bring to our mind again what is behind the regional councils. And first I thought that would be a very easy task, but after the opening speeches of the three gentlemen, I can say basically they have already done my job. They have explained in the best possible manner what is behind the idea of regional councils. So at the beginning, it was really so that we thought, how can we further contribute to improve policy making and policy implementation? And we have it heard already by our team leader. We wanted to help to have a more evidence approach and a bottom-up approach for policy making. And our idea was that in the region we still have resources which are widely unused, at least not used in a structured and sustainable manner. And we wanted to make these resources available to the decision makers in Kiev and at the same time achieve that regions have a better saying in policy shaping, that they are able to bring up to the mind of decision and policy makers their expectations, the challenges which they see, and also the ideas which they have. So in order to achieve that, we thought it would be fantastic if we could, in main regions of the country, set up core teams, sustainable teams which represent all legal professions and discuss topical issues for the country and bring it really to the mind of policymakers in Kiev. But we wanted to go a step further by also inviting academia and partially students to the discussions, and also enable civil society, and the Vice Minister mentioned it, how important it is, to enable society also to play their vital role in shaping up policies. And that is why we came up with the idea of regional councils. That is the main idea behind this concept. And I can say that we are all very proud and very excited that together with you we managed really to have stable groups in all of the regions in which we are working, stable groups of people who are really not representing just their profession, but who are also representing a huge willingness and excitement about pushing reforms forward. And these groups have, and we heard it and we will hear it in more detail in a few seconds, have put together already policy papers which have been triggered the attention of decision makers in Kiev, for which we are very grateful. And we hope that in the next step we will be even able to have a more structured dialogue with those decision makers here in Kiev and invite them to make use really of the resources which we have. And before I pass the floor back to my colleague Oksana, who will introduce you really into the hard facts and figures, I just want to make one last remark to our results today, to the impact which we had today. And it is my absolutely belief that the existence of the groups which are regularly meeting and the networking between legal professions within the regions, but also across the country, is already a big result as such. Whatever happens politically in the country, whatever the pandemic is forcing us to do, we have these groups working in 6 of the regions of this wonderful country, and I think that is unprecedented, and that should be not underestimated as a result as such. Oksana, I promised you to leave you enough time for the hard facts, so thank you very much.
Спасибі, Карстене. Так, колеги, я хотіла б
Dear colleagues, I would like to present some outcomes and achievements of the regional councils in their collaboration with the executive powers and with the working groups within the state authorities. I would like to talk about 5 main areas. The first one, that's the enforcement of court rulings. Mr. Zorin and Mr. Solko from Lviv and Dnipro are drafting the amendments to the law on the forcible enforcement of court rulings, and they are designing this draft under the Committee of the Parliament on the Legal Policy, and they're paying a lot of attention to the aim that the state enforcement officers and private enforcement officers should have similar or equal rights. The second area is one of the most important, is the digitalization, and it's even more important within the lockdown situation. And Dnipro Regional Council is a pioneer in this area. ANDRIY RISHCHENKO, the judge, had the first ruling now in Zoom, and together they are designing the solutions for e-court rulings. The third area is the bankruptcy. And we should acclaim that representatives of the regional councils from Lviv, Kharkiv, and Donbass are members of the working group of the Ministry of Justice of Ukraine, which is dealing with the improvement of legislation on bankruptcy. So they are analyzing the code on the bankruptcy procedures and other bylaws. Today we will sees the expert panel discussion of this working group, and members of our regional council, Mr. Artemovich, the deputy head of the economic court, Mr. Roman Chumak from Kharkiv regional council, and the stakeholders from the central level. The fourth area is the legal education, and with the active participation of the representatives of the regional council from Chernivtsi, Odesa, and Kharkiv, the standard of higher education was adopted on law for the masters. Tatiana Stepano and Matsukivsky from Odesa University were collaborating actively on developing the standard, which was approved in August this year by the Ministry of Education of Ukraine. And to wrap up, the alternative disputes resolution is another area, and the Kharkiv Regional Council were actively participating in the working group of the Ministry of Justice of Ukraine, which was designing the draft law on mediation. And now this draft law was adopted by the parliament in the first reading, and we do aspire that this draft law will become a framework legislation. I'm very thankful to you, and I would like to invite the regions and to pass the floor to them, and we will move to the success stories, challenges, and the plans for the future. So we will come back to the broadcasting in 5 minutes.
Колеги, ми розпочинаємо.
Dear colleagues, we are starting our next session about the success stories of the regional councils. And I would like to invite our colleagues from Dnipro, Sergei Savchuk, the coordinator of the regional council from Dnipro. Sergei, Alexei, sorry, good afternoon. Thank you. In the morning, I was still Alexei. I'm Savchuk Alexei, and I'm the coordinator of the Dnipro Regional Council. First of all, I would like to thank Pravo-Justice for the possibility to collaborate, and to my great team from Dnipro. We managed to unite around us the representatives of all the legal professionals. These are both the bankruptcy trustees, the judges, the deputies of the local governments, the state officials, also the lecturers, also the private enforcement officers, and we have already conducted a number of successful events. And on the presentation, you could see that we are united around the reforms. It's great that we have the possibility to collaborate with the representatives of other regional councils as well as international experts. We have received some positive outcomes. The reform on the bankruptcy and enforcement of the court rulings and mediation. We already have first achievements on our collaboration with the Ministry of Justice and the Parliament. our action plan for the next year is not only to continue the work which we have started, but also to broaden our collaboration not only with the professionals or the legal profession, but also to go to the common people. First, we think that we should collaborate with the business because they are united in trade unions, and they are speaking loudly about the necessity of transparency and fairness of the legal system of Ukraine. We should reform not only the system, but also to increase the trust to this system by the society. I would like to pass the floor to the judge, who was the first one to conduct the Zoom court hearing. Now the floor is yours. Good afternoon. My name is АНДРІЙ. I am the judge of the Dnipro District Court, who at the beginning of April this year was the one who conducted the video conference in a Zoom app. So when the transport was not functioning and everyone was at home due to the lockdown, and the possibility was given to the lawyers, to the claimants, and thus we made the legal aid available to everyone. And a lot of attention was paid. So Open Data Board was advertised, and then the Council of Europe also published about this. And on our next session we will speak more about the digitalization. And I'm a member of the Dnipro Regional Council. So there are a number of questions from people what we are doing. We are finding individual solutions for legal challenges. We were not conducting our sessions in a usual form, but we have conquered the digital world. We have analyzed the issues which arose, and also we paid attention to the issues which were not looked at. Next year, we would like to make the court accessible to different vulnerable groups of people. That's why I would like to pay a lot of attention to development of the digital services in courts and to make them popular. Another area is the improvement of the open court hearings. I think you will agree that it's not very good when the regional council is deciding with the society how to rename the street, but the local governments are not advising with the locals when they are closing schools or some other activities. So the main motto of our council, we believe that reform is not a process, but a feasible outcome. That's why we believe that all members of the council will do everything possible to achieve those outcomes. Thank you, Andriy, for sharing your experience. Alexei, I'm also thankful to you. You will still be Alexei, sorry for the mistake at the beginning. And we were happy to hear your experience. And I believe that we will collect all those successes and also the digital services and plans for the future and collaboration with the business and also the protection of business.
I'm now pleased to invite the Lviv RJRC to take the floor. Coordinator Marta Muchulska. Marta, good afternoon. Good afternoon, dear colleagues. I hope you can see and hear me well. Greetings from Lviv. I'm pleased to present the results of Lviv RJRC for 2020 and share our plans for the future. I need a moment to share my presentation with you. In 2020, we focused on the following issues. Reform of the justice sector, judicial reform, and other aspects of administration of justice in Lviv region. Here in Lviv, we are also focused on administrative justice. By the way, of the administrative justice monitoring, the Lviv region provided the most of statistics data used for the monitoring. We're also very much interested in communication and mediation and other issues.
Потрібні якісь деталізованіші інструкції щодо її функціонування, потрібна належна технічна підтримка, оскільки саме в умовах карантинних обмежень саме електронний суд може бути надзвичайно корисною та актуальною. В умовах карантину важливою
Under the lockdown conditions, it is extremely important to ensure smooth communication between courts and court users, as well as ensure the security and safety of court staff. Unfortunately, in Lviv region, anti-COVID practices in various courts are used to be different. Now we are improving and somehow streamlining these conditions. So we managed to address legal challenges that arose in the region in connection with the lockdown and to unify the So we somehow systematized challenges that arose in Lviv region in connection with the quarantine. On this infographics, you may see the results of our work, which we present in the form of digest. So the digest lists challenges that arose in the field of administrative justice, bar practice, legal businesses, etc. We cannot but mention the perspectives of Lviv RJRC work for the future. So we would want to enhance cooperation with local public authorities and legal community. We've already set up some working relations with the above-mentioned categories. However, there is still room for improvement. We would also want to increase our media coverage and media presence. Among other priorities is the enhancement of communication with stakeholders, with public authorities, with local authorities, with the legal community, and individuals. We're also planning to ensure a greater engagement of stakeholders. So we are planning to invite more stakeholders and to enhance the list of participants of our working sessions. We would want to spread our messages and share ideas, exchange ideas, and all in all, enhance the spirit of cooperation. Despite the lockdown restrictions, we managed to keep the momentum and continue our work in more or less usual way. So in this picture, you may see members of the Lviv RJRC. We do hope that our work in the 2021 will be as successful as it was in 2020. Thank you, Marta. Thank you for your extensive presentation. Thank you for focusing on some key results that you've already managed to achieve and on your plans for the future. We're looking forward to working with you in 2021, and I can only imagine what your achievements at the end of next year will be. I'm now glad to give the floor to Olena Fonova, coordinator of Donbas RJRC. Olena, the floor is yours. Good afternoon. Can you hear me? Thank you. My name is Olena. I'm a representative and coordinator of Donbas Regional Council. Donbas region is a very specific one. This is why the problems and challenges that arise in the region are quite particular. Let me share my presentation with you. Some technical issues are occurring. Unfortunately, I can see Marta's screen on my computer. Can I share mine? Thank you. So since 6 years, the armed conflict is taking place in the east of the country. Almost 1.5 million people are internally displaced, and more than 1.5 million people continue living on uncontrolled territories. Naturally, it brings about multiple problems that the state has to deal with, and many of them remain unaddressed. Donbas RJRC works with the purpose of informing the state about challenges and difficulties the region is facing in terms of legal aspects. So we work closely with the working group on the reintegration of temporarily occupied territories under the Presidential Legal Reform Commission. We participated in the development of the concept of transitional justice, covering such issues as reimbursement to people who lose their property or who lost their property, and ensuring proper protection of their property rights. Another major issues, alongside the one I've already mentioned, were covered in the digest drafted by the Donbass RJRC. Among them, access to court, lack of mail correspondence with certain parts of Donetsk and Luhansk region. Loss of case files, especially in criminal cases. Issue relating to the fact that Ukrainian inmates stayed on uncontrolled territories and their destiny remains unknown so far. So, as I said, all the above-mentioned problematic issues were covered in the digest prepared by Donbass RJRC and put on table during the discussion with the Presidential Legal Reform Commission. In the meantime, the Donbass RJRC came up with possible solutions. All in all, Donbass RJRC insists on the promptest development of solutions to the above-mentioned issues. I would also want to take this opportunity to address decision-makers. Please be so kind to take into account the possible solutions we have already suggested. Our third major area of intervention is raising public awareness. Why is it so possible? It's so important. It's important because people, in order to accept changes suggested by the state, need to understand what these changes are intended for. Raising awareness includes organizing a series of online events, basically webinars, which provide information on e-access to court, possibilities of submission of case files via electronic services, possibility to participate in trials online, as well as informing on some practical legal issues such as a possibility to file for individual insolvency and online means of communication with the respective legal professionals. So these webinars are intended for people who live in Donetsk and Luhansk region, including in the uncontrolled territories. And I believe if at least one person from uncontrolled territory finds this information useful and actually uses it for their purposes, we can consider the webinars to be a success story. It may sound surprising, but people who stay on the uncontrolled territory may not even have information about the availability of Ukrainian courts online. So we are doing our best to overcome these challenges and to address the problematic issue. At the end of my intervention, let me say how pleased I am to be part of this friendly and meaningful network doing so much efforts for the legal reform in Ukraine. Thank you. Thank you, Olena. Thank you for your intervention. I believe that the results in terms of awareness raising in the Donbas region are of particular interest and importance. We are sure that it is absolutely necessary to inform people about legal issues in a simple and understandable language. I'm talking, for instance, about individual insolvencies, which is of relevance for citizens. I hope that we will manage to ensure even greater awareness raising. Now I'm pleased to give floor to Roman Chumak from Kharkiv, RJRC. Roman, you are welcome to present the results of Kharkiv Council. Thank you, Oksana. It's true that Kharkiv situation is very particular because Kharkiv is considered to be a hub of scientific and legal dialogue. We have so many brilliant professionals brought up and working in Kharkiv. What we have in mind when conducting our work is that changing minds will change the country. Kharkiv RJRC brings together various professionals and the state values such professional hubs of professionals which can be there to make a quick analysis of suggested pieces of legislation or regulations. We know that policy implementation in Ukraine used to happen only from up to down rather than bottom up. We are here to change this approach. We want people to become real initiators of reforms. Kharkiv region worked on bankruptcy amendments, enforcement amendments, mediation law, and the unified judicial telecommunications system. We believe the goal of Kharkiv RJRC, the ultimate goal, is to provide services. We want to create services which would be available and user-friendly. So usually user-friendliness becomes, when it becomes a common thing, remains almost unnoticed. For instance, I, as a citizen of Kharkiv, may receive some formal documents in 5 minutes. It became possible after the Kharkiv city administration digitalized the list of Kharkiv's inhabitants. Our goal is quite ambitious. However, 1 year ago, nobody could even imagine that we would be able to hold an event like this, which is a hybrid event. However, here we are. The event is happening. That is why we are planning to hold similar events to work in the same format next year, and hopefully we will manage to do so. Thank you, Roman. Thank you for making such a perfect and ardent presentation. So we are here coming back to the idea that RJRCs are moved forward by people, and I think that it's just marvelous that you mention people and how important they are, how important their role is. I'm now giving floor to Valery Pritulak from Odesa. Valery is coordinator of Odesa RJRC.
Good afternoon, dear colleagues. Thank you for the possibility to take a floor. My name is Valery Pritulak, and I'm a private enforcement officer, and I'm the head and coordinator of the Odessa Regional Council. In our council, we also have the judges, the academia, the lecturers, and so on. So these are the experts in their areas. About our council, we should say the following. At our council, we have collaborated and also had a lot of outcomes in mediation, in the forced enforcement of court rulings. Also, the e-court is one of our priorities. But today I would like to speak more about the main achievements which we can be proud of. First of all, that's the enforcement of court rulings, the first one. So let's have a look at the presentation. If we speak about the statistical data, according to the Eurocontrol, the debt on the court rulings is more than 1.5 trillions of hryvnias. So only around 5 to 10% of court rulings are being enforced. What it means? It means that more than 90% of the court rulings which should be enforced not enforced. It means that children do not receive the cost from their parents. Then the person who had a car accident cannot receive the refund. Or if there was a damage of a flat by the flood, then the owner cannot receive the reimbursement as well. Unfortunately, we can see also the negative statistics in the European Court of Human Rights, where Ukraine is in the top 3 of the countries which is not enforcing the court rulings. That's a great issue which we have to solve. The outcome of our council we can see in what we have already achieved. It's a European package of documents on the amendments to the legislation on court rulings enforcement. What is foreseen? That to broaden the powers of the private enforcement officer. Now the Ministry of Justice published the statistics on the effectiveness of the state enforcement officers. But if you could imagine, if the private enforcement officers could join in those actions, then if we had similar powers both for state and private enforcement officers, the numbers would be greater. Also, we are for the increase of the assistance of the private enforcement officers. But unfortunately, according to the assistance of the private officers, the legislation does not foresee that these staff can act similarly. Then the seizure of the assets is another issue. Of course, if our proposals will be approved, it will enable us to show greater numbers. When there will be the automated blockage of accounts, and then the person will have enough funds on their accounts. What should we say as also? All those proposals will allow us to make our country more it's better looking for the investors, because the investors will be sure that they will have an effective legal system with a functioning enforcement system. Because if the court ruling which was declared but not enforced, then there is no trust to this system. That's the first part of the proposals of our regional council. Another huge part is dedicated to the bankruptcy area. The new code on the bankruptcy procedures were adopted, and it's a dramatic one which has changed a lot. But we already have noticed some drawbacks. In the work of the regional council, we have prepared the proposals to eliminate those drawbacks. For example, an issue on the work pay of the bankruptcy trustee. Also, the change of the bankruptcy trustee if the committee of the creditors do not like the work of this bankruptcy trustee. And those proposals are based not only on the experience of our regional council, but also from the experts of other councils, because we usually invite the expert from other councils to get the relevant information not only for one region, but all around Ukraine. And all those proposals are further transferred to the committees of the parliament. And this policy from grassroots to the top is a very good one, because we can see small drawbacks which could be eliminated only on the highest level. In the code on the bankruptcy procedures, there are some which are in fact very topical. And the proposals which we suggest allow us to get the goals which we are aiming at. Now we can see that we have the cases when a natural person was considered a bankrupt. And it allows a person to start a new life. This person can start his or her life from the scratch and become a member of the society. On this positive outcomes, I would like to end my speech. And also, as we had the representatives of the Ministry of Justice and also the MPs, and in the Committee on the Legal Policy, we have a package of laws which is aimed on the improvement on bankruptcy legislation and also on the enforcement of court rulings. I do hope that this draft law will be adopted in the parliament. And also remark of the Ministry of Justice mentioned that all the draft laws will be discussed with the community. And you have this community, the regional councils from Odesa and other regions do provide the information. So please, let's adopt this legislation and make our country better investor. Thank you for the openness and for the readiness for collaboration, both with the Ministry of Justice and with the Committee of the Parliament on the legal policy. And as the Pravo-Justice project, we will support you in this collaboration, and we will facilitate your dialogue. Now I would like to pass the floor to the Chernivtsi Regional Council, Mrs. Irina Buturska and Mrs. Oksana Sherbanyuk. Do you hear us? Good afternoon. Can you hear me? Yes, we can hear you quite well. First of all, I would like to start our speech by the fact that our regional council is a specific one. We have not only the judges, the prosecutors, the enforcement officers, but also a lot of members represent the Chernivtsi National University by Yuri Fedkovich, and also the students. So, and we believe the students are not the future, but they are the present. And it's very important that our council understand that we should be the same. So what is interesting about the council of Chernivtsi? We collaborate very effectively with the students, with the legal community as well. We also invite the students to the decision-taking process. Also, the pro bono assistance of students in different assistance, and we also use the proposals of the students to how to improve the process of education. And also the students are discussing the novelties and the suggestions of the legal system. And we believe that in this way we are forming the new society, and while they are communicating with other students who are not lawyers, they are sharing the information, the knowledge about the reform. So what is the outcome? The members of our council, for example, Vitaly Shevchuk had education in Canada, and another one became student in Oslo. So what we have achieved in those 2 years? We have functioned very actively. We had conducted 2 international conferences about the current issues on the legal system. And we invited the representatives from the academia, not only in Ukraine, but also Poland, the Netherlands, and Germany, and also the MPs and representatives of parliament. Our council was participating in the monitoring of the administrative justice, also the e-justice and enforcement of the court rulings. And all the participants of the council are the representatives of all legal professions. We are a small region. For us, it's very important that we have horizontal connections with other councils, and this exchange of experience was great. The positive experience which we had last year when we had this pan-Ukraine legal school with the participant students from all over Ukraine, and it was with the support of the Pravo-Justice. And also we had the assessment of our educational master and bachelor's programs, and our representatives of the council, together with the other council representatives, took part in drafting the standard of the higher education. Thanks. And now I'm inviting your colleague, the coordinator of Chernivtsi Council, Irina Putirska. Good afternoon. Thank you for the possibility. I would like to present the issues of the small and medium enterprises as one of the new areas. At the January 2020, we had 31,000 enterprises, and around 20,000 are small and medium enterprises. And those enterprises and entrepreneurs are very proactive, so they are united in some unions or business clubs, and that's why our regional councils could not stay away from the challenges which they face. We only start the collaboration with the representative of the SMEs, and we can talk now only about the issues which the SMEs have already told us about. The first issues, these are the tax disputes. That's the area where both parties are always not satisfied. So on one part, the state is willing to have enough funds from taxes. From the other side, the entrepreneurs are not happy with how the taxes are calculated. Another issue is the disputes with the anti-monopoly bodies. And quite often those disputes are not even coming to the court, because the lawyers do believe that there is no sense in submitting a claim against anti-monopoly bodies. The third area is the land disputes, and a separate issue, the consequences of the pandemic COVID-19. So when the lockdown was introduced, the level of the funds decreased a lot, so there are large cases of insolvency, and the entrepreneurs cannot pay the salaries. Also, the paying of the contracts and the rents are quite complicated now to pay for the entrepreneurs. Also, the issue is the following, that the new legislation is being adopted, and as a result, the entrepreneurs are not following those amendments, and that's why they make the mistakes. For example, they are saying that the state paid the allowance for non-employment, and that this allowance should not be considered as a profit, but it should be indicated in the tax declaration. That's why those who have not included it into the tax declaration
чітко розповідати людською мовою підприємцям, як
So entrepreneurs need to be properly informed about how to proceed to respect the newly adopted legislation. Our plan for the next year is to turn the Chernivtsi RJRC into a platform for polylogue among businesses, lawyers, and local authorities. Not only are we planning to bring up existing problems, but also come up with possible solutions. We will also focus on awareness raising activities, including printing some brochures, manuals and guidelines which might be of relevance and use for lawyers, legal professionals and businesses. Thank you. Thank you, Irina. No doubt problematics for small and medium businesses are worth discussion, since these economic agents are facing problems more than any other categories of economic agents. Thank you again, Irina. We are a bit behind the schedule, but we will anyway take time for a short discussion with the regions. I'm now giving the floor to Kharkiv part of our team, or better say to the part of our team which is located in Kharkiv, since Kharkiv hosts today members of both Kharkiv and Donbass RJRCs. So dear colleagues from Kharkiv, are you willing to take floor and say something? Denis.
Спробуємо ще раз.
Let us have another try. Dennis, we can hear you. I'm giving the floor to colleagues. Good afternoon, colleagues. Yevgeny Ryako, lawyer from Kharkiv. First, as a practicing lawyer, I have to say the following. I've heard most of all about the enforcement system reform. This reform entailed the greatest reaction and just feedback from businesses. People would ask, is it now really possible to get a court decision enforced? There are some other problematic issues which are relevant for Kharkiv region, but they might also be relevant for other regions, and it's something that we can put on our agenda for the next year. So the first issue is continuous training, also known as raising qualification. So Ukrainian legislation envisages continuous training for various legal professionals, but they are mostly unhappy with the quality of continuous training, which is provided. Second big issue includes procedural codes. So civil procedure code and economic procedure code were amended recently, which brought about some difficulties with the calculation of terms of proceedings. And all the professionals agree that the issue of terms of proceedings need to be clarified. Third major issue is the relevance of existence of the state judicial administration. Various representatives of the judicial quorum put under question the necessity of existence of the state judicial administration. And last but not least, so we as lawyers find it difficult to explain to our clients what the advocates, the lawyers' fee is, and judges do not have any uniform opinion on this. This is why it is difficult for winning parties to get lawyer's fee reimbursed. Thanks. Yevgeny, thank you for putting on table these issues. We will definitely consider the possibility of including the above-mentioned problematic issues in Agenda 2021. Odesa, floor is yours. Good afternoon. I'm giving the floor to Svetlana Sergeyeva. Thank you. It's a pleasure to join our today's event. I have something to say regarding the mediation draft law now pending before Parliament. The draft law is being prepared for the second reading. Odesa RJRC fully supports the draft law on mediation. I personally, as Pravo-Justice expert for mediation, cannot but stress how important it is to adopt a framework law on mediation. We don't want having this area over-regulated. We really want to have a framework law in place. Mediation is of relevance for various legal professionals, not only mediators, but defense lawyers, private enforcement officers, bankruptcy trustees, and other legal professionals. Effective enshrinement of mediation into Ukrainian legal system depends a lot on proper understanding of what mediation is by key stakeholders. What we also need is to raise public awareness about mediation. We receive great support from the Pravo-Justice with this. So a promo video on mediation has been prepared with support of the project. It is also very important that project experts are directly involved with legislative drafting, working with the respective parliamentary committee and decision makers. I truly hope that the mediation process will be properly enshrined into legislation, which would be for the benefit of all the players. Thank you, Svetlana. I'm sorry for not giving floor to everybody. We are a bit behind the schedule. I'm inviting you to join panel discussions. We are now starting discussions in panels, and we will be back online in 3 minutes.
the Legal Reform Commission. Official name of the working group is much more comprehensive. And then we will ask Mr. Burominsky, Deputy Chair of the Legal Reform Commission, to add a bit. We are behind the schedule, and that's why we have to excuse our distinguished guests. They will leave shortly because they have an important meeting with the President. With the President, any meeting is very important and good excuse. So please, I will then continue some comments after. Mr. Korinevich, you start. Mr. Burominsky had the chance to greet our audience, so yes, please.
Thank you, Mr. Svanidze. Do we talk in English or in Ukrainian? Any. Okay, then maybe in Ukrainian for it to be easier to understand. Доброго дня, шановні колеги. Я дуже вдячний.
Thank you, dear ladies and gentlemen. I'm grateful to Mr. Svanidze for making a short intro. I am very pleased having this possibility to speak today. Unfortunately, I and Mr. Mikhailo Burominsky will have to leave since we're having a meeting with the President of Ukraine in 40 minutes, so my apologies for not being able to stay with you. The Pravo-Justice project has been supporting Ukrainian government since the very moment of its deployment. The Legal Reform Commission was established under the President of Ukraine for limited period of time. However, last week the President of Ukraine just issued a decree which prolongs the mandate of the Commission for a longer period. In the framework of the Legal Reform Commission, we discuss various areas of reform, justice sector reform in Ukraine, including reform of legal education, quality of justice, administration of justice, and so on. In the meantime, we also focus our particular attention on the occupation of temporarily occupied territories in Donetsk and Luhansk region and on the Crimean Peninsula. We appreciate a lot the support received from Pravo-Justice in various areas. We've achieved a lot so far. We have some tangible results in place. We've recently developed the concept on transitional justice, which has already been presented before the President of Ukraine. Transitional justice for an average Ukrainian citizen means administration of justice, amnesty, the responsibility, while our concept is wide and covers also human rights, reimbursement, satisfaction, moral satisfaction, and other issues. That is why our preoccupation for the moment is how to properly present our concept, present to both citizens who remain on controlled territories and those dwelling on uncontrolled territories. All in all, we are doing our best to bring the transitional justice discussion from legal community to state policy. The reloading of the Legal Reform Council has already taken place, and we are happy that this reset was successful. We will do our best to bring up the transitional justice on a brand new level.
Знати, зрозуміти.
It's a great possibility to analyze the key challenges which arise in the regions. That's why we always join the efforts of the Kharkiv Council efforts, or in Lviv. If we will speak about Crimea, then we will join this regional council meeting. We believe that it's an important mechanism of our work. We believe that today the president will give us the tasks which we are ready to fulfill to move from the occupation to the peace, and that our citizens will live in a peaceful country, that those will live that those people will live together, except those who committed the crimes against humanity or collaborated in the local government. Thank you. It's my second chance to speak. The first one was a very brief greeting. Now I will speak on the matter. Maybe it will be even broader than the panel discussion we have right now. First of all, I would like, of course, to thank Mr. Korunevich for the way how they collaborate in the working group, because they have achieved high results in this very complicated area. One of the specificity of this group is that they have the representatives of the NGOs, and they know quite well the situation, and they give the possibility to this group to have this fact-based approach and society-based approach. But I would like also to underline that as a commission under the President of Ukraine, so we function not as a separate body, but as a body which has to advise to the President to support him in his legislative initiatives. And in this sense, the Commission works very actively. Though there was not much information, I would like to say that we have some collaborations already, and what Mr. Korunevich already mentioned about the reintegration group. It's one of the blocks which is very important, and it's great that there are initiatives there, and that those initiatives are being paid attention to, because it has also the political value to the processes which are now happening in those temporarily occupied territories. But there are also areas which require attention, and Pravo-Justice support them. And I'm speaking about the constitutional reform. We are moving forward in this area. And almost a full ready package of drafts were submitted to the President. These are amendments with a number of discussions and involvement of NGOs and regional associations. And this package of documents is almost ready and will be moved to the next stage. About the criminal law, this draft is being discussed to the general part of the code. It's one of the most complicated tasks, because everything further will be based on this renewed division of the new criminal code. Also, we work on the criminal justice reform, and also the legal education. So the volume of tasks is quite huge. And the constitution of this commission was recently renewed. And we have the MPs as members of the commission. Thus, we have a broader coverage and coordination of efforts, the legislative initiatives, namely. Also, this makes us more flexible. But this commission is a huge platform for discussion, and everything what is being drafted in the commission should be as much transparent as possible, and the society should know what is happening. The commission is the center of the expert work. These are the experts of legal professions who can share their knowledge. This possibility to invite the experts and will give us more possibilities for deeper and broader discussion with the experts. Thanks for the collaboration, and I'm reiterating the idea which I already said. The project which is linked with the discussion of the sector of justice, and it's a key area of work for the commission. It's a very complicated area, but I'm sure that we will achieve the necessary outcomes. Thank you for your attention, but we have to go because today we have the meeting of the president with the commissions.
That the legal reform commission, how it works in action.
It works, it's continue to work.
Yeah, okay. Yeah, thank you. And
thank you very much.
We are in touch, and of course, we continue our cooperation. I skipped some introductory remarks to this session. And the idea behind it, it's not only related to the very subject matter which we are discussing, very sensitive, very painful for Ukraine, but also it demonstrates the developments which are very much supported by our project. It's linking the top policy making in the country, or central policy making, its leading body, the commission, with the regional councils, and the kind of informally building these strong connections, links and cooperation. So you don't need me to mention the importance of getting feedback from the regions. It has been many times highlighted. The very rationale of having regional reform councils is related to this idea, and here we once more are trying to demonstrate at today's event even that this is a kind of a model which has been just launched. It's far from fully fledged, let's say, cooperation and work, but this already demonstrates that we have established this working relationship, and the central policy steering body is getting feedback loop from regional reform councils on very thematic issues, and one of them, as I mentioned, is very topical and once more I have to say very painful for Ukraine. And here we have representatives from the Donbas regional council, which I am happy to pass the floor. We continue according to the sequence in the agenda. I believe Ms. Fonova is joining us on
Lugansk.
Yeah, I see that she is from the Luhansk. She is a judge of the commercial court of Lugansk regions. She is joining us online, I believe. Yeah. Yes, please.
Ще раз вітаю.
Good afternoon. Unfortunately, the sound was not very good. I would like to speak about one aspect. In order that we could collaborate and communicate with citizens who are on those territories, this is the topic which is very important for us. I'm sorry, I could not get what she's saying. A lot of people are living on the territories which are not under control of Ukraine. And they, of course, need the same type of services which do people from all around Ukraine need. A lot of services they are trying to receive online. So they have either to get to the post office or to receive the card from private bank. And the point is that not all people can get these cards, and we should remember that there are a lot of elderly people and they could not do this due to physical conditions. So we have to speak about the fact that we have to renew. Yeah, I'm sorry. get the message that it's very complicated to hear me. Yeah, so we have to restore the post connection. So we can do it in 3 ways. First is to in the gray zone we have to place them. For example, at post office it could be maybe an alternative way of posting, not Ukrposta. At least the letters, I'm not the packages, at least only letters could be sent there. And from the uncontrolled territories they will get these letters. And so this transitional post, which will not need the border crossing from either of the parties. Now also there is another issue which was also spoken a lot is that the post offices will not and the state authorities will not consider the letters which if they were not sent by the specific persons. So it could be one of the improvements if we could establish the post offices in the specific zones. Maybe another solution could be the sending and handing of the letters by the international organizations such as Red Cross or other organizations. So in this way we could solve the issue of not receiving the letters and in this way we could connect both the Ukrposhta and the post services on the uncontrolled areas, and it will guarantee the access to justice. And why the issue of the letters and so important, because the court could not inform those people who live on these territories that some court proceedings were open with their involvement. And in this way people could monitor whether something is happening about them. That's why I would like to reiterate that the post office services is one of the most important services which could facilitate the reintegration of those regions. It could be one of the ways to boost the connection between Ukraine and those citizens.
Indeed, access to justice in the context of temporary occupied territories, it's very, very complex and difficult issue to solve. In general, access to justice is quite a sophisticated mechanism that should be streamlined and ensured through different means. But yeah, here we have one more example, demonstration of how what are the difficulties we face apart from political and whatever physical constraints. Yes, and with this I would like to pass the floor to Madam Olena Skovoroda. She is chair of the similar court, president, sorry, of the similar court from Donetsk, for Donetsk region, and one of the leaders of regional council, and our hosts when we come to Kharkiv, unfortunately. So before you start, I would like to dream about time when you would be able to host in Donbass, in Donetsk in particular. So please, yes.
Дякую за представлення мене.
Thank you for the introduction, Eric. I'm very grateful to the Pravo-Justice project for all the efforts the project is applying and for turning our court into the platform where we can speak out the problems relating to the Donbas region. As my colleague Olena mentioned, it is now easier to give messages regarding our region than it used to be. I will speak today about some concrete things that raise our concerns. I'm talking about issues which are relevant for all legal professionals, notaries, lawyers, and others. I'll try to focus on three major issues. And in the meantime, let me say that before dealing with transitional justice, we have to address problems arising in connection with the armed conflict. The armed conflict is lasting for almost 7 years already. As to addressing the problem of movable property, so the term of validation for movable property consists 5 years. For instance, if certain state-owned movable property was just rented to some private economic agents, after 5 years of use, such an individual is entitled to keep the property in their ownership. So if the property is now being used by a person who rented it, it means that such a person may come to any Ukrainian court and claim ownership over such property, which means that Ukrainian state will lose their respective property. So some amendments, legislative amendments, need to be introduced in order to suspend the term for such movable property. I do hope that Ukraine will gain back its territories. However, the reintegration process will take long, and we are risking to have the similar situation with real estate. So we used to consider only buildings to be real estate. However, real estate also includes land plots, just equipment of various enterprises and so on and so forth. The acquisitive prescription for real estate in Ukraine constitute 10 years. So we have 3.5 years until the expiration of the acquisitive prescription. So again, we are risking losing immovable property, land plots, buildings, and etc. The issue has not been addressed so far, so I, as lawyer, can see only one solution. Respective legislative amendments need to be done. Mr. Korinevich covered the various aspects of the transitional justice, and he said that the reimbursement issue is being addressed in the framework of the concept on transitional justice. It is indeed a very important question. However, I think that respective measures need to be put in place in order not to make the respective provisions of transitional justice concept applicable towards bankruptcy property. By the way, the bankruptcy of legal entities whose property remained on uncontrolled territories constitute a considerable legal problem for Ukrainian justice system. Such bankruptcy cases are pending while they need to be closed with the possibility of to be reopened in case of the acquisition of access to respective property. If we talk about major industrial enterprises, I doubt that such enterprises are not operating now. So we cannot consider them to be as non-operational. So we have to just implement measures for regaining such enterprises once the uncontrolled territory are brought back under Ukrainian jurisdiction. In the meantime, some bankrupts which are registered on uncontrolled territories may possess property remaining on controlled territory. So we should not be guided by the place of registration of such enterprises. And in case such enterprise goes bankrupt, the bankruptcy trustees and creditors need to take into account and properly consider the property which is located on controlled territories. Banking institutions are also facing certain problems with solvency, especially if assets of banks remained on uncontrolled territories. Thus, such banks are unable to comply with their obligations before clients. So, property which remained on uncontrolled territory is currently inaccessible. However, it may become accessible in a few years after the territories are reintegrated. So in smaller bankruptcy cases where creditors' claims can be satisfied after the sales of such property, there should be a possibility for innovation. However, there are major economic agents which went bankrupt and which do possess some property on uncontrolled territories. But even if sold, such property would not give enough cash to repay all the creditors. So here we need to close the bankruptcy cases and just leave them as they are. Another major issue, some people who own land plots or building or any other pieces of real estate on uncontrolled territories would approach notaries with the request of alienation of such property. However, this issue is not properly governed by the existing legislation. According to existing legislation, such transactions may be certified either by a notary who has jurisdiction either in the place of registration of property or in the place of registration of the owner. So once a potential client is registered in Donetsk, for example, it means that only a notary from Donetsk may certify such a transaction, which makes the transaction certification literally impossible. There is an order by Ministry of Justice allowing notaries from other regions to certify such transactions, but the wording of the order is vague. That is why notaries would just refuse certifying transactions. I personally believe that the above-mentioned MOJ order does not properly entitle notaries from other regions to certify transactions regarding property located on uncontrolled territories. So if notaries do so, it may entail an avalanche of lawsuits in the future. If notaries from controlled territory are allowed to certify transactions in respect of property located on uncontrolled territories. We will make lives for our citizens dwelling on uncontrolled territories much easier. Thank you.
Or rather, overview of the multifaceted implications of related to or concerned with the property rights. These issues and framework is in itself very complex and complicated, but in the context of temporary occupied territories, it becomes even tripled or whatever the complexity. And with the statutes of limitations and many issues that have their specifics in the given context, yes. To cut my comment and thanking Vanya Olena once more short, I would suggest, if I would be in your MP's shoes at Rada or leadership of the ministry, I wouldn't promulgate or proceed with any legislative or regulatory changes concerned with these issues without, if not regional council, Donbas Regional Council having looked through it, at least some of its experts should be invited to and kindly asked to filter and look at whatever they propose in terms of regulations and practicalities. With this, I would like to pass the floor to Mr. Alvydas Medelinskas, who is one of the maybe not founders, but I could say founders of Rada, and was with us as from the very outset even of the idea of regional councils and supporting this initiative, which is now more than just initiative, and he at the same time works with in the field, based in Mariupol, still in Mariupol, yeah, I'm not mistaken, and working and facing all the complications, practicalities in his daily work, daily life as a leader of civil society organization Donbassky Vorota. So I pass the floor to him, and yes, please, Aldis.
Thank you very much, Eric, for your kind words and introduction. Yes, really, I was very happy to contribute what I could for the establishing of the Donbas Regional Council with all my colleagues here. I am a political analyst, I'm not a lawyer, so therefore when I'm looking to the issue of Donbass, I'm looking more really from a little bit more wider prospects than only simply issues of legal issues, justice issues, and so on. For me, it's more also political issues. I'm former politician. I am former chairman of the Foreign Affairs Committee in the Parliament, former chief advisor to the president, but also was participating in the civic activity in Lithuania. So therefore, from me to look to the Donbass issue, it's also very much important, like looking how various state institutions in Ukraine, maybe with the help of international experts, could solve such a very difficult and sometimes unique issue like reintegration of Donbass territory by not making any harm to Ukraine and just having it, this reintegration process as a success story. From the other side, I think also it's important how those people in Kiev, maybe from the national institutions, really connect to those people, to the professional community of the people from various legal professions, from various state institutions in those two regions, Donetsk and Luhansk in Donbass, and how civic society could be vibrant and contribute to those processes. But before going here, of course, you said that our NGO, Donbass Gates, where I'm the deputy chairman, is international expert, is based in Mariupol, but of course we're working over the Donbass area in Donetsk region and also in Luhansk region. I am spending my times in various towns, cities, even villages, to understanding the situations there. So first of all, I would like to say that I would like to make, let's say, the 5 points in order to understand how this situation with Donbass Regional Council is a different one, a little bit from the rest 5 regional councils. And what Olena Skordina and Olena Fonova already told it, it's also reflect this situation. Well, first of all, and also what Anton Korinevich is doing with this reintegration commission. It's also important. So first point, I mean, the challenge of the reintegration of Donbass, it is not only external challenge because it came up from the Russian hybrid warfare against Ukraine in Donbass, but it's also a challenge in domestic policy for the social stability because the wrong step in the wrong direction it could create also the social problems for the social stability because the people are very sensitive to this issue. So that's important to understand. Secondly, I think what's important to understand that in talking about Donbass, sometimes people, and even for example, like now this institution like Korinevich Commission and others are talking, we're talking about Donbass, which is the occupied or under Moscow control, whatever, another side of Donbass under the division line which divided Donbass. But there is also Donbass territory, which is under Kiev control, and where I predicted myself as a political analyst, but now we all see these results of the local elections, clearly shows that there are also problems for the Ukraine as the state in the Donbass territory controlled by Ukraine, controlled by Kiev. And the fact that following those local elections, only local political regional groups were the winners, and only one political party was almost in the whole territory of Donbass, was among those who presented, that is the political party like opposition platform, as this create like alarm bell for the Ukrainian politics and understanding how much new efforts have to be devoted, that those pro-European, other strong political parties, civic society organizations would be present in Donbass and the people would hear what they are saying. So this is important. The third thing, it is really a unique case with Donbass, that there is a very big movement of people across a dividing line. So that's a totally different from the situation of, well, there are no similarities, of course, but different situation from, let's say, Kashmir situation between India and Pakistan, between the situation what was in the Balkans, between the situation which is in the, let's say, between South Ossetia and Georgia and Abkhazia, proper Georgia. The different situation, then it is also in other areas. So what does it mean? That means the people on both sides of divided Donbass are communicating between themselves. And every step which is done in Donbass territory, for example, Donbass territory control of Ukraine, it is a positive step. It brings closer reintegration process because the people say, oh yeah, with such kind of justice situation, I would like to live. It's much more better than to live in the situation with injustice, which is on the other side. Or even the building of the roads could be a good symbol, good example, how things are working on that side. But at the same time, the wrong step also echoes on the other side and make a more distant way of the reintegration. So we have to have in mind this echo principle of such. The fourth point, and I think it's important, now I'm coming to what both Olena Skоворodina and Fonova was talking about. It is a question, of course, Ukraine have a final goal, reintegration of Donbass. But some steps could be made already now, maybe not necessarily only, and it cannot be made, let's say, by the judges in Kharkiv commercial court, or by the judges in Kramatorsk, Luhansk, or Mariupol, or whatever. Those steps have to be made maybe with the help of some, not just international experts, but international institutions, whatever, OSCE, Red Cross, and others, and to see what is possible to do in this transitional period in order to make, let's say, transitional gains for these issues. And the issues of the property, what Olena Skоворodina was talking, or issue of communication, what Olena Fonova was talking, I think those issues which have to be addressed. And the fifth point, what I wanted to address, and of course we had Anton Kornech, with whom we are in very close contacts before, and now there is very glad that there is a close contact between the Donbass Regional Rada and his Reintegration Commission. But there are also other initiatives in Ukraine which also have to be kept in mind. For example, just yesterday I was talking to the people in the Ministry of Interior about this program of small steps in Donbass. We also know about diplomatic activity of the President's office and some other politicians, President Kravchuk and others, in the Minsk trilateral group. So there are various initiatives which are coming up in the parliament. There is a committee which deals with the occupied territories, and so on and so on. And then it's really the question how those various initiatives could be put to the package, which could be also presented as idea in the region, in Donbass region. First of all, to the professional community, what we could do through the council, Donbass Regional Council, but not only to the Donbass Regional Council, but also professional community, like people who are in the police, people who are in the prosecutor's office, who are in the courts, judges, and so on, also in the area. And this is quite big challenge for such projects like EU Project Pravo-Justice, but also others, how to deal it. But I think that if we will make right steps towards this direction, we all will help for this very important task for Ukraine, for successful reintegration of Donbass. Thank you very much.
Thank you, Alvydas. It's very difficult to moderate these kind of sessions because I don't dare to interrupt because the issues are so hot and again painful. Yes, but we exceeded our time a lot. Thank you, Alvydas. You talked about political dimensions. Political dimensions of this issue. Now, questions and answers, if there are any. No questions, interventions. Our colleagues in the regions. Yeah. Thank you. Then the session is over. Now we thank to the panelists, and we have a technical break, which will give us a chance to catch up a bit with time, I hope. Thank you.
Доброго дня. Ми раді перейти до такої.
Good afternoon. We are very happy to move to this very practical session as bankruptcy and bankruptcy procedures. It's one of the topics which was in the focus of the regional councils, as well as the topics of the enforcement of the court rulings. And we have here the representatives of the MPs, the Ministry of Justice, and also the head of the Association of the Bankruptcy Trustees, and also we have the representatives of the regional councils. And on the case of the individual bankruptcy, we would like to show how it is linked from the regional council. So I'm inviting Taras Tarasenko, who is an MP. He is the head of the working group on the bankruptcy group in the Parliament of Ukraine. Good afternoon to everyone. I would like to thank to Pravo-Justice for the active support in developing the bankruptcy system and alignment of the bankruptcy legislation. And of course, the experience of the regional councils and collaboration communication in the regions brings the real effect, because the practice in different regions is different, and in different courts and in different regions. Especially the bankruptcy of the natural person. It's a novelty, and the code of bankruptcy is enforced only for 1 year, and the courts are facing this topic, which is completely new for them. So the liquidation of debts of the natural person is a complicated task, because the code is active for 1 year, and we had only one bankruptcy of a physical natural person with a rehabilitation plan. Usually the banks and the creditors are appealing, and because they believe that the debtors are not showing all the assets in the courts. The bankruptcy of the natural person as an element of the legislation is a needed one, but it should be separated.
Це банкрутство валютних позичальників.
So the first issue to be addressed is the indebtedness of those who took credits in foreign currency. There is a moratorium which is now in action. However, we are awaiting for amendments to the Bankruptcy Code of Ukraine, which will exclude the loaner, those who took loans in foreign currency, from individual insolvency. I personally is against such a novelty, and I will submit an alternative draft of amendments so that foreign currency loaners are not excluded from insolvency, individual insolvency. If not addressed, this issue will remain there for many, many years. Another big problem is the lack of agreement between banks and loaners regarding the calculation of the amount of debt in the framework of restructuring. There is no common position on sole place of residence.
будинок розміром 250 метрів.
Which cannot be taken away from the chapter in the framework of the bankruptcy procedure. Currently, Ukrainian legislation says that the space of sole place of residence cannot exceed 140 square meters when it comes to apartments and 250 square meters for privately owned houses. So these numbers are not backed up with any evidence or objective reasons. That is why I believe they need to be changed. They need to be reduced. Foreign currency loaners are unhappy with my proposals, of course. However, we need to come to terms at the earliest convenience because otherwise this problem will remain pending for indefinite period of time. Currently, the Human Rights Committee is setting up an inter-committee team which will deal with the development of a legal mechanism of human rights protection in the framework of bankruptcy procedures and enforcement procedures. We have also faced and find solutions to problems rising in connection with the lockdown. Small and medium enterprises are most affected with the lockdown restrictions, and they are at risk of bankruptcy in this connection. That is why we're thinking of having a simplified bankruptcy procedure for such enterprises as well as for individuals in order to speed up the process of clearing of debts and financial recovery of respective economic agents. Another big problem constitute people who who took loans to buy houses and apartments on uncontrolled territories. So mortgaged property of such individuals stay on uncontrolled territories while people could have moved from uncontrolled territories to controlled territories. In the meantime, banks are trying to take away their apartments and houses purchased on controlled territories, which is, of course, unacceptable since force majeure conditions and contract terms are applicable to the mortgage property remaining on uncontrolled territories. Thank you, Taras. So indeed, the bankruptcy working group has become a platform for discussion between decision makers and borrowers. So the dialogue is happening under the close oversight of the respective parliamentary committee. I'm now inviting Vasil Artemovich from Lviv RJRC to take floor and to deliver his presentation on private insolvency. Good afternoon, everybody. My pleasure to attend this highly respected gathering. Let me suggest you a short overview of Lviv District Court practice in individual insolvency field. I hope that my overview might be of use for decision makers, lawyers, and court service users. Can you see my presentations? Not yet. Since the Bankruptcy Code came in force, we received 71 applications for individual bankruptcies. So basically, we received 71 applications for bankruptcy, and only 1/3 out of those applications were individual insolvency applications. Article 7 of the new code says that all lawsuits relating to the debt must be tried in the framework of a bankruptcy case initiated against such a debtor. 63 lawsuits relating to bankruptcy cases were filed to our court so far. As the General District Court of Lviv region and Economic Court of Lviv region are constantly communicating on all issues relating to bankruptcy cases dealt with in respective courts. Out of 29 cases on individual bankruptcy, only 12 cases were actually opened. All the rest were all other claims were either returned or suspended, mostly for the reason of non-payment of services of a bankruptcy trustee. Out of individual individual insolvency cases submitted to Lviv District Economic Court, only 2 individuals were recognized as bankrupts. One preliminary session was scheduled, while all the rest applications remain at the pre-trial stage. To sum it up, since 1 year, our court and our judges came to a conclusion that the individual insolvency tool has become operational. We also witness that Article 7 on the concentration of all cases in respect of a debtor within one bankruptcy case has become operational as well. However, the number on individual insolvency cases has not increased dramatically, and there are reasons. First, the complexity of the procedure, and second, the necessity to advance the remuneration of a bankruptcy trustee. Currently, the advance payment amount constitutes some 1,000 euros, which means that individual insolvency mechanism need to be improved and streamlined. Dear colleagues, thank you for having me here, and thank you for the project's contribution into the development of bankruptcy tools in Ukraine. Thank you, Mr. Artemovich. So Mr. Artemovich listed reasons for individual insolvency not becoming as popular as we could had expected. Mr. Taras Tarasenko outlined some problems relating to loans in foreign currency, which was also very interesting. And now I will give floor to Valeria Kolomiets, Deputy Minister of Justice for Enforcement and Bankruptcy, and she will also make her presentation. Thank you for the invitation. It so happened that I'm not only responsible for bankruptcy, but also for free legal aid. Ministry of Justice made a decision to keep low profile in terms of individual bankruptcy, since members of parliament are quite successful in leading this job and as well as engaging other stakeholders. MOJ decided to focus on bankruptcy of state-owned enterprises. In the meantime, I know that individual insolvency exists in many European countries, and my colleagues from such countries called on paying more attention to this legal instrument. In Ukraine, legal aid system will become part of efforts relating on restoring the solvency of individuals in Ukraine. To put it in an easier way, legal aid lawyers will provide with legal advice eligible individuals who are about to go bankrupt. So lawyers will just inform legal aid system clients about the availability of individual insolvency tool and about all the conditions. So recently there was a joint event held by FLA system and BTs. I'm very pleased that two professions find common points and areas of cooperation. It is indeed very positive, and I truly hope that this happens not only in Lviv region, where I attended the event, but also in other regions. It's true that some amendments to Bankruptcy Code are needed in order to enhance access to individual insolvency. We as MOJ need to streamline cooperation between legal aid providers, thus lawyers, and BTs. In the meantime, it's not on our priority list. That is why I guess that more initiative should be displayed by the legal community so that Ministry of Justice could be sure that there is will from the side of legal community to develop this area. We'll see whether it works. We'll see whether there is demand for such type of free legal aid services. So once we see that legal aid clients need to be advised on individual insolvency, we will just do all necessary arrangements in order to give them this opportunity. We are currently at a stage of discussion and exchange of opinions in this respect. So again, thank you for your contribution into the implementation of various positive legal initiatives which are designed to give access to legal services which are demanded by the society. Since several years we see that it's not just some efforts pro forma, but some efforts which translate into tangible results. I personally am very pleased to cooperate with the BT community, who are long-term partners of the Ministry of Justice.
I would like to support what has been mentioned by the Deputy Minister. Why this Institute of the Natural Persons Bankruptcy? The fact that people do not know about this notion, and would like to say that communication through the regional council is a very important one, and the Donetsk regional council, which was conducted by Olena Fonova, that's a communication with the potential debtors, with the debtors, potential users of this institute. And now I would like to pass the floor to Mykola Lukashuk, who is the head of the National Association of the Bankruptcy Code of Ukraine. He will comment and will say his stand. Thank you for the project, for the Minister of Justice, for so nice words about our collaboration. We have analyzed the amendments to the code concerning the idea how to simplify the procedure of bankruptcy of individual persons. And we would like to mention how we are going to solve this. First, it's to amend the Article 116 on the Code of Bankruptcy Procedures, that when there were violations in the proceedings, then the bankruptcy trustee is not appointed. Of course, a lot of issues should be done by the bankruptcy trustee, that the cost and also designing the rehabilitation plan, and also the fact-checking of the declaration of the debtor. We would also to pay attention that the court, the commercial court, cannot collect the evidence. So when there is a dispute, and usually also cases about the bankruptcy should have two parties, and it's only the bankruptcy trustee had the responsibility to collect the evidence. What we would like to mention that there will be no possibility to have the claims in the cases of the bankruptcy if there are no bankruptcy trustees. So maybe we will have this model which we had in the Article 52 up to 2013. So when the asset was discovered, then the procedure was moved to a different type of case. Then if the bankruptcy trustee will not receive the payment for the services. What else we have noticed in the amendment? First of all, that the rehabilitation plan is shortened in the time. We had it 15 to 10 years according to the active code, and now the suggestion is 7 to 5 years. To my mind, it gives more pressure. It makes more pressure on the natural individual, and then the sum which should be defined by the financial possibility of the debtor. But there's no procedure how to define this possibility to pay by the creditor. And in the suggested amendments in the projects which are suggested, there are no details how those issues could be solved. We think that in the working groups together with the MOJ and with the National Banks of Ukraine and the MPs, we should have a wide discussion, maybe to invite some representatives of the debtors, and also to introduce such amendments when it will be possible to communicate together with the free legal aid system, and that the documents will be prepared by the bankruptcy trustees, and they will submit those documents to the commercial court. So if you, as you can see, around 50% of cases are declined. And in many cases, the issue is that the documents were not properly drafted. And this integration will allow those persons who are now in this credit situation will have the possibility to receive some assistance. To my mind, we have to integrate the free legal aid assistance with the bankruptcy justice, and it will be a very good collaboration which will help a lot of people. Every draft law has a lot of issues which have to be still solved further. I would like to invite the last speaker of our discussion, that's Roman Chumak, representative of the Kharkiv Regional Council, the bar, and expert of the project. 1 year passed after the code came into effect, and now we could speak about some sums up. So there were no great claims to the court. And why? Because the procedure is costly. So, for example, if in Kiev or in big cities, this cost is not high comparing to the revenue of general people. But if we analyze this cost for Lugansk or Donetsk region, then this cost is too high. So what are the ways how we could solve it? If we see the experience of Poland, and this new national natural persons bankruptcy started functioning only when the state started paying the free legal assistance. That's why we believe that in Ukraine, if we could introduce the system with the involvement of free legal aid, then this procedure will become less costly. But if we look further, when the lockdown is over, when the quarantine is over, a lot of people will have those credit obligations which they will not be able to fulfill. Now there are a number of organizations which provide loans to the citizens, and the citizens will not be able to fulfill those obligations. It should, through the free legal aid system, the state could be involved through financing the payment for the bankruptcy procedures. And secondly, we should move forward by simplifying the package of documents which should be submitted to the court. One of the judges just showed how many documents had to be submitted to open the case. It's not possible to prepare this type of documents by one person without any assistance. So in this way, if we get the assistance of the free legal aid assistance, I think also that for those creditors who have loans in foreign countries, they should have a separate approach. And the regional councils are constantly submitting the amendments. We have also to conduct some work on information campaigns, maybe webinars, as Olena Fonova told for the first time about the bankruptcy of natural persons. So people will know more. Thank you. So if you have any questions, we are ready to answer. If there are no questions, then we finish our panel discussion. It was a short presentation of the specific case of the issue of natural persons bankruptcy, which is very topical for the
Доброго дня, точніше, добрий вечір, шановні колеги.
Good afternoon, dear colleagues. I hope that the regions are still with us. We will be with Roman, Andriy, and our third colleague from Chernivtsi, Ms. Christina, will be very brief. Our session is called the Administration of Justice in the Lockdown. I will just tell a few words that our project was very active in the topic of the administration of justice during the lockdown, and we were analyzing before the lockdown about the issues and gave our expert comments and drafted the strategies how the system should be organized, how it should be function. And when we started the lockdown on the initiative of Mr. Roman Babia, our main colleague with whom we are collaborating on the e-justice, we analyzed the system of remote communication, how we could use them, and how we could have this e-justice. We tried Skype, Web, Zoom, and we also analyzed UZICON, and then finalized this analysis through Confidence and Microsoft Teams, because these systems are used by some judges. I hope that Mr. Roman will tell us more about the development of e-justice and about the collaboration with the project. And I will be very thankful when Andriy will join us, as from the beginning we were interested with their experience. They were the first court who started usage of Zoom. Thank you for waiting till this time. Thank you for all the participants participating, those who survived, who were willing to join our session. First of all, I would like to thank not only to the participants, but also to the organizers who are doing a lot to move forward in this area. They are supporting a lot. Thanks to Pravo-Justice and to the regional councils who joined this event. I'm the head of the working group under the Committee of the Parliament of Ukraine on the digitalization of the legal system. So the issue of digitalization became even more topical within the lockdown situation, and administration of justice during the lockdown is very important, because we are facing those challenges right now. And of course, since March this year we had some limitations, and the Parliament also reacted through adopting the amendment, and the judges had the possibility to limit the number of the audience, and then the right of video conferencing was proved. We knew that the video conference were available from courtroom to courtroom, and now they were liberalized, and the participants of the court rulings received the possibility to participate in the court proceedings, not only from the courtroom, but also from their dwellings and through their own technical devices. And in March, the quite disputable provision was introduced about the automated prolongation of the term of terms of reviewing the claims. So it was the issue of consensus, and some of the factions were putting the question this way, that either we are voting for this amendments, but also for others. So it was a compromise. So this provision was adopted, but the life showed us that the lockdown was not only 2 or 3 months, and it's still on. That's why we had to modify this provision, and now we know that the administration of justice was almost blocked because the court rulings could not be enforced, but in June the law was adopted which deblocked this, and the court rulings are being proclaimed. And now I would like also to speak separately on the most effective mechanism which we have during the lockdown. That's this video conferences. And the feedback on the usage of this mechanism is the following. It's quite positive from what I know, at least at the beginning there were some drawbacks. The DCA issued an order, and there was the monopoly of EasyCom, but then there was the wave of critics, and in our working group we analyzed it, and then the order was changed, and now the court are using not the EasyCon. It's good that this software is being developed, but they can use also other tools and other applications. And Pravo-Justice, as Pauline already mentioned, provided the analysis of this software applications, and it's not the one which is the most applicable. But the judges are using this software, and I know that they are using also Skype and Zoom. Video conference is used for a huge
Instrument.
Video conferences are not widely used, however,
Здійснення правосуддя. І багато колег зараз
so many colleagues, especially in the bar community, call on keeping this mechanism even after the lockdown is over. I think that we will consider the possibility of application of such a mechanism after the lockdown as well. The procedures we are having enshrined in procedural codes can still be improved. For instance, the Unified Judicial Information and Telecommunication System need to be launched. UGITC is a very ambitious project. It is quite complicated to launch the Unified Judicial Information and Telecommunication System in full. In this connection, our committee has developed a draft law which envisages the step-by-step implementation of UGITC. Online communication is something which will become widely available once UGITC is in place. I'm talking here about exchange of documents alongside the participation in trials. It also includes availability of case files online and the possibility to handle such documents online. These are the major issues to be addressed now while the lockdown restrictions are still in place. certain modules of UJITC could have been better developed over these years of the UJITC elaboration. According to the SJA, electronic cabinets for judges and lawyers will be ready soon. So there are still some work to be done. However, it is on its final stage. We also have problems with the SJA, State Judicial Administration. The chairman of SJA resigned. First deputy is not in office either. That is why we don't have real interlocutors in the State Judicial Administration. Fortunately, the head of the state enterprise information judicial system is in office. We are currently working on the development of the concept, action plan, and roadmap of UJITC implementation. So there is a coordinator a person who coordinates work in this field, and hopefully we will soon end up with a roadmap developed. The most painful problem is, of course, funding. The State Judicial Administration could have launched electronic cabinet after January 2020, as they promised. However, financial problems made it impossible. There are funds lacking for the finalization of the system as a whole. The State Judicial Administration also works on the improvement of EasyCon video conferencing program application. Money is needed to complete such improvement. SJA and relating authorities could have considered and might want consider the possibility of using alternative applications solutions such as WebEx or Cisco. By the way, the expenses on TrueConf would be equal to what SJA currently spends for the support of the existing application. When I say that the expenses would be equal, I don't mean that the functionality available would be the same. To wrap it up, even though the pandemics changed our daily routine and somehow made it more turbulent, on the other hand, it just kick-started the development of e-technologies, not only in Ukraine, but all over the world. Many other countries across the world have been implemented various e-solutions to ensure the administration of justice. We've organized a series of conferences where we looked into practices of other countries and sharing our experience. RJRCs, judiciary, and all those who are relating to this process should join efforts to promote these ideas and to have issues discussed, because the working group cannot do all job just by itself. We need to have more people speaking out loudly in order to speed up work. Thank you, Roman. It's true that we looked into practices and experience of other countries, and we realized that we were not unique, and we were not by our own in this endeavor. All in all, we realized that in order to ensure long-term development and sustainability of e-solutions, there should be proper planning and setup of priorities. Second, we are ready to be part of the digitization strategy. We're also making some inputs in the development of the strategy. We're also ready to engage professionals. Before giving the floor to Mr. ANDRІЙ, let me say the message which we received on multiple occasions from our colleagues from other countries. So a key prerequisite for the success of e-solution implementation is having proper feedback from users. So in order to develop an effective e-solution, the developers need to make sure that their work will be relevant for people who use the respective services. In order to achieve such user feedback, we organize multiple discussions involving judges, lawyers, other legal professionals, court users, and others. ANDRІЙ RIŠČENKO is the first judge in Ukraine who issued a court decision via Zoom. So he is a first runner in this field, and he is the one who managed to do it with due respect of all existing legal requirements. I'm now giving the floor to Mr. RIŠČENKO while expressing my gratitude to Mr. Roman Babi. Good afternoon, ANDRІЙ. My pleasure to see everybody here. Thank you, Roman, for your contribution in the e-court development in Ukraine. You're doing a great job. I'm also grateful to the project for making efforts in the e-justice development. So because of the lockdown, e-court services has become more and more demanded. So in 2021, we will need e-justice solutions even more because of the lack of funding that we are expecting in the judicial system in 2021. So this, unfortunately, this is something that we cannot solve in the legislative field. Starting from 2008, we started back in 2008. We started building up the development of e-justice in Ukraine. However, only in 2019 we had the concept of the UGITS developed and approved in the country. So, building up e-court system in Ukraine has a long story. There were multiple obstacles on the way, such as lack of funding, revolutions, Maidans, etc. This year we are having COVID. However, the COVID-relating situation forced us to speed up the process. Over the year, we realized that the solutions we have developed are not as good as we thought they would be. We realized that the existing video conferencing systems needed improvement, and fortunately, EasyCon system for criminal trials is now being updated and improved. However, many issues remain unaddressed. I think that our key problem is lack of planning, because it seems like we are building up a house without knowing how it is supposed to look like after all. Video conferencing. Starting from April 2020, court hold trials online using EasyCon, TrueConf, Skype, Zoom, and any other systems allowing it. However, in summer, our court was deprived of the possibility of holding video conferences online because of the indebtedness before Ukr service provider. There are, in the meantime, courts where no video conferencing or UGITS usage are possible, just because their hardware dates back to 1990s. The Pravo-Justice project held analysis of the equipment used for video conferencing and other equipment in courts across the country. I won't go into details, but that analysis was quite detailed. So video conferencing for trials became widely used in Ukraine since spring 2020. However, there are trials which cannot be held through video conference. There is still no unanimous approach regarding the applicability of video conferences on trials where witnesses have to be interviewed. According to existing legislation, it is not possible, because before giving evidence, witnesses have to put their signature on a specific document. So it's something which is written in legislation. It's not something that cannot be changed, of course, but no amendment has been implemented so far. We have cases on administrative offenses which cannot be tried via video conferencing either. We have
подати до суду електронні документи.
So now the claimants could submit the documents in the electronic format. There were some issues with downloading, uploading them. So I would like to tell you about the back side of the e-justice. In the transition provisions of the code, there is a provision that we could use the electronic systems, the e-seats, from the moment when there was a publication in the newspaper that this system started function. I know that there is a draft law that this provision should be changed to part by part functioning of the system. But what we have right now is that in some courts there is a practice that the documents should first be submitted through the system without the publication in the newspaper, and others are doing this. Another issue is the printing out of these documents. In the instructions, there is a provision that the case should be printed out, and to print out these claims with the addendum, they have a huge number of paper. Our court, we have a very proactive citizens who are submitting the claims every day, and the volume of this claim is around more than 100 pages.
І знову у нас в тому самому режимі. Тобто ми витрачаємо ресурси суду на роздруківку шалені, але це можна було б скоротити. Далі. Проблема електронного суду, в ньому досі немає можливості повідомлення сторін. Тобто, нам би полегшило роботу питання можливості повідомити сторону за допомогою якогось електронного повідомлення на офіційну електронну адресу. Відповідний законопроект також існує. Ми чекаємо, чи буде він прийнятий, тому що на повідомлення сторін також у суду витрачається значна кількість ресурсів. Вже якщо ви слідкуєте за Фейсбуком або за сторінками судів, то ви побачите, що багато судів зараз повідомляє про припинення повідомлення сторін за допомогою поштового зв'язку, тому що немає взагалі марок ні конвертів для цього. Що хочеться сказати? Ну, не все у нас так, дійсно, не все так погано, але могло би бути краще. У нас, відповідно до концепції, є дуже значна кількість, там близько 20 модулів ЄСІЦ, які плануються запустити. З них є модуль, який буде відповідати за бухгалтерію суду. Є модуль, який буде відповідати за кадри суду. Є модуль, який буде аналогом Microsoft Word програми. Але є ті модулі, без яких ми наступного року, мабуть, не зможемо працювати. Це модулі обміну документами всередині суду, тобто які б виключали необхідність роздруківки документів. Це модуль повідомлення сторін засобами електронного зв'язку, і це нормальний модуль відеоконференц-зв'язку. Про EasyCon, про який казав пан Роман, хочу зазначити наступне.
Пане Андрію, якщо тільки можна, будь ласка, вкластися в 1 хвилину завершити. Я дуже вибачаюсь, бо в нас же зали просто потрібно виходити через 10 хвилин максимум. У нас ще 1 спікер. Дякую.
В судах. EasyCon, TrueConf – це програми, які для запровадження для проведення відеоконференц-зв'язку. Так от, EasyCon наразі не має можливості відеозапису відеоконференцій, тобто ми не можемо його прикласти до матеріалів справи. А TrueConf нам рекомендують не використовувати, тому що розробники цієї програми є з Російської Федерації. Отже, я впевнений, що ЄСІЦ найближчим часом може запрацювати певним чином, якщо ми всі разом об'єднаємось і свої зусилля і викреслимо ті проблеми, які нам необхідно вирішувати в першу чергу, і сконцентруватися на них. Дякую.
Дякую, пане Андрію. А пані Кристина є з нами з Чернівців? Так, добрий день, пані Кристино. Ми дуже вибачаємося. Ми зразу попросимо вас вкластися буквально 2 хвилини, бо в нас просто технічно ми маємо вже завершити захід і маємо вийти із зали, тому дуже вибачте за затримку. Будь ласка, прохання 2-3 хвилини. Дякую вам дуже.
Дякую. Доброго дня. Чути мене, скажіть, будь ласка?
Так, чутно, добре.
Доброго дня, шановні колеги, ще раз. В принципі, попередні спікери вже достатньо розкрили ту тему, про яку ми хотіли поговорити. Єдине, хочу додати, що Конституція України визначає, що навіть в умовах воєнного чи надзвичайного стану робота судів не може бути припинена. І дійсно пандемія, яка є на сьогодні, коронавірус, який є світовою такою проблемою на сьогодні, вніс певні корективи в роботу судів. Зокрема, скажімо, в нас з березня місяця почався новий відлік, який ми вже проходимо і до сьогодні. Дійсно, коронавірус показав нам, що судовій владі, як і будь-якій, потрібна діджиталізація. Тобто перехід більше до електронних засобів фіксації судового процесу. Хочу сказати, що ми з початку пандемії, тобто з березня 2020 року, ще більше, звісно, почали працювати в електронних системах. Ми почали більше проводити відеоконференцій. Ми розпочали роботу по проведенню відеоконференцій з учасниками судового процесу поза межами суду і ефективно її зараз використовуємо. Крім цього, звісно, електронний суд набув більше популярності серед відвідувачів нашого суду, і ми далі до нього закликаємо, тому що насправді ситуація, яка сьогодні існує в Україні з коронавірусом, вона не дає нам забути про те, що нам потрібно переходити на такі засоби фіксування. Хочу єдине додати до попередньої доповіді пана Андрія про те, що ми дійсно маємо проблему на сьогодні з електронним судочинством, як мінімум в тому плані, що ми дійсно маємо обмежене фінансування, і тому саме на суд лягає той тягар роздрукування матеріалів судових справ, оскільки ми не маємо. Другою проблемою є нормативного врегулювання передачі цих справ в межах навіть суду. І маємо ще третю проблему – це відсутність у фізичних осіб фактичної реєстрації в цій системі електронного суду. Тому, звісно, це в нас викликає ті проблеми, що ми не можемо в більшій мірі перейти для розгляду справ в електронному вигляді. Хочеться також зупинитись на тому, що коротко закінчувати доповідь тим, що нововведення, які нам ввела ця пандемія, це робота дистанційно не тільки канцелярії суду, але й повністю апарату, пристосування суддів і працівників апарату до того режиму, який нам наразі диктує час. участь учасників справи у віддаленому режимі. Ми теж до цього звикаємо. Спочатку дійсно було важко, ніхто не міг подумати, що ми будемо працювати в такий час, але ми маємо сьогодні таку ситуацію. Відтак вчимося працювати саме в таких умовах. І ще хочу сказати, що адміністративні суди в плані роботи наразі є трішки такими спеціалізованими, в плані того, що ми наразі розглядаємо виборчі справи і поєднуємо процес пандемії коронавірусу з майже цілодобовою роботою в зв'язку із розглядом термінових категорій судових справ, це виборчих справ. У нас на розгляд справи 2 дні, а відтак нам приходиться налагоджувати таку роботу по терміновості і по тому, щоб максимально убезпечити людей від оцих скупчень, скажімо так, і переводити цю роботу в електронний вигляд. Як висновок уже і попередніх доповідачів, і свого, хочу сказати, що нам дійсно потрібен ЄСІЦ, нам дійсно потрібне електронне судочинство, тому що воно не тільки полегшить роботу нашу і суддів, ну тобто апарату і суддів в період зараз пандемії, але це наша реальний крок вперед, так, до електронного судочинства і надалі, навіть коли у нас буде вже звичайний режим, ми дуже на це сподіваємось. Ось, нам дійсно потрібно йти вперед і добиватись того, щоб ми могли працювати в електронному форматі. Дякую.
Дуже дякую, пані Кристино. Від себе, завершуючи нашу сесію, хочу подякувати нашим спікерам, хочу подякувати Роману за те, що він завжди стоїть на сторожі активній позиції розвитку ЄСІЦ. І саме за допомогою робочої групи у нас є така серйозна платформа, де ми можемо тепер комунікувати. І дуже дякую Кристині Андрію, оскільки дійсно регіони і користувачі, в даному випадку представники судів, вони є основними юзерами, основними користувачами, до яких потрібно прислухатися. І ми зі сторони Pravo-Justice завжди робимо. Лише додам, що також важливим питанням є саме передбачуваність. Незалежно від зміни влади, від політичної волі, системи мають розбиватися. І саме це дасть можливість забезпечити сталий розвиток і в кінці ефективність та неперервність процесу побудови інформаційної системи. Не буду більше забирати вашого часу. Всім дуже дякую. Ще раз дякую спікерам нашої панелі. Гарного вечора.
So thank you very much for staying with us for our last session for today. You can recognize that we come to an end when you see that our team leader is again with us. But before he will close the event, I would like to introduce to you our new colleague, Alina. Alina is helping Oksana and me in the future to coordinate RJRCs. And this additional effort which the project puts into making RJRCs running and assisting them is also a sign of satisfaction and a sign of really big hopes into the work of RJRCs for the future. Alina will now talk about communication. We started just to work with RJRC members on a better visibility and coordination of their great work, because we are absolutely convinced that this will contribute to a better sustainability and make the work of RJRCs more impactful. Alina, please.
Thank you, Carsten. Доброго дня, дякую, що ви ще залишаєтесь з нами. І мені би хотілося...
Thank you for staying with us. I would want to present our developments on RJRC communication for 2021. We are thrilled to have Marina Marmeladze on board. Unfortunately, Marina, who is a communication expert for the project, cannot attend our today's event, so I will make a presentation in her place. So communication is supposed to put in place and achieve strategic goals of RJRC. In order to enhance the activities of RJRCs and give them broader perspective, good communication strategy need to be in place. Our key communication goals include becoming main newsmakers in the region, to be able to pass a message to the center. It's extremely important that coordinators and RJRC teams give proper and prompt feedback on new challenges. It's also important to engage new people from various areas into discussion. So what are the components of communication strategy? They include multiple aspects. Marina would be in a better position than me to present all these components. So if I may, I will not give you details on the topic. I will just say that it's important to teach RJRC coordinators some communication skills and techniques. We've been talking about the achievements of RJRCs so far. We are a lot behind the schedule because we needed so much time to cover all the achievements and success stories of RJRCs. However, in order to be able to reach out a greater audience, wider audience, we need to have some communication strategies in place, which would cover not only legal professionals, but also wider public. So since recently, Regional Justice Reform Council have its webpage. It contains comprehensive information on RJRCs, RJRC members, and the recent news. Thank you for demonstrating the webpage. We can go back to the presentation. RJRCs are planning to use multiple communication channels or instruments. You can see the list of such channels on the screen. So again, these communication channels are intended to turn RJRCs into key newsmakers of their respective regions. I would also want you to see these faces. These are people who, since 2 years, have been closely involved into activities of RJRCs. So they are already working hard on reforms in the regions. And now I give the floor to Karsten.
A very interesting introduction into our new thoughts, which we developed together with the regional councils on communication. And as Alina said, we have very good experts on that who are working for us and together with you. And we will in the future really invest in this part of the activity a lot, because again we are convinced that is part of giving more impact to your work and also increasing the sustainability. I think it has been a long day. It has been a very interesting day for sure, and I'm very happy and proud that we were able in these times to conduct still that kind of meeting. We put a lot of effort in it together with you, and I think we didn't sink the ship, but we made it work. And I would kindly ask our team leader Dovydas now to wrap up and to close the event.
Thanks, Carson. Да, действительно, я думаю, очень был интересный ивент. Мы показали, во-первых...
It was indeed a very big and important event. We managed to demonstrate vertical and horizontal connection which exists between the center and RJRCs and among RJRCs. Horizontal level is especially important because when we had that idea of setting up regional councils, we realized that sometimes people who would, legal professionals who would work in one city would not really know each other. RJRCs became a platform for introduction and communication among professionals in the first place, but also between regional legal community and the center, of course. I'm happy that we managed to set up this network, bringing together various legal professionals from all over the country. We managed to promote some extremely important ideas for the for greater performance of the justice sector in Ukraine, for the benefit of Ukrainian individuals and businesses. Speaking about our plans for the future, COVID-19 did not affect our work in terms of its content-wise, because Some processes have even intensified. Under the COVID lockdown, we have been holding RJRC sessions and meetings online, and even though we are looking forward to going back offline because we are really missing this human factor, but the pandemic's limitations have in no way affected the intensity of our work. So next year, we are planning to keep up with the current speed, and we hope that we will continue enjoying the same level of cooperation and support from Ukrainian stakeholders. So in parallel with our today's meeting, the Reset Legal Reform Commission under the President of Ukraine was sitting. They are our major partner, and we count a lot on the cooperation with this institution. So I encourage everybody to keep going, to stay in contact with decision makers, with key people in ministries and governmental bodies, to constantly remind them about us, about us having ideas worth their attention. So these are our expectations in a nutshell. We hope that we'll go back to you soon with some new proposals and new ideas on our work in regions. We've been implementing several initiatives with the NGO sector. There was a survey on the structure of state debt in Ukraine. The survey showed that the major part of existing debt is owed by state-owned enterprises. This work has not been finalized. Once we have any finalized information, we will share it at the earliest convenience. By the end of November, we are planning to present the results of survey on small and medium enterprises and on difficulties such enterprises are facing in connection with COVID-19, and in connection with other factors. Some of the problems faced by businesses can be addressed only in the legal field. We will also continue working on ADR, including mediation for the promotion of private enforcement officers' profession and a more effective enforcement system alongside a more effective bankruptcy system, state registration system, quality of data, e-government, electronic registers, prevention of frauds relating to property rights. We will also continue our joint work with the prosecutors, judiciary, and I truly count on RJRCs in doing this job. I have many expectations for 2021. Thank you.